reasonable doubt that you did this. If you enter a plea of no contest, then we're not going to have a trial. You're going to admit to the facts of this. A no contest plea means, Mr. Everhard, that you don't necessarily admit that those facts constitute a criminal offense, but a no contest plea is not a mini trial. So it's not like you would say, okay, I'm going to plead no contest, but I still want to dispute those facts. That's not how that works. Do you understand that?
Yes.
Okay. Because there's also something called an Alford plea. An Alford plea is different from a no contest plea. An Alford plea is a guilty plea that essentially says, I didn't do this, but I'm going to plead guilty to this charge because I don't want to face the possibility of the consequences following a trial. So I'm going to enter a plea of guilty so that I don't go to trial, even though I maintain my innocence. Do you understand that?
Yes, sir.
All right, some people confuse those. Mr. Everhard, how old are you?
25.
How far did you go in school?
11th grade.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to this charge, you have a couple of, if you enter a plea of no contest to this charge, you have a couple of options. The first option is that I can set this over for sentencing in a few weeks and conduct a pre-sentence investigation where we look into your history. We basically do some homework about you and about your life, and that may help me reach a better decision as to what to sentence you to. The other option is we can go forward with the sentence today. I've indicated to your attorney the sentence that seems appropriate based on what I know now, which is a 6-year mandatory prison sentence plus 4 additional 1-year or 12-month terms to be served consecutively for a 10 to 13-year sentence. That seems like that's appropriate for what I know about the case, but those are our options. Do you understand that?
Yes, sir.
Has anybody made any threats, promises, or representations to get you to plead guilty to this against your, no contest to this against your will?
No, sir.
All right, I have a document entitled Change of Plea and Entry, and it looks like on the 4th page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Kirby before you signed it?
I believe so. That's what we just went through, yes.
Yeah, this is the document, right, Mr. Kirby, that you went through?
It is, Judge.
Are you satisfied with the representation that you've received in the case?
Yes.
You're going to be entering a plea of no contest. Count 1 is trafficking in a fentanyl-related compound. Count 2 is possession of a fentanyl-related compound. These are each second-degree felonies, which means they're punishable by up to 8 to 12 years. When I say 8 to 12, this is subject to what we call a Reagan-Tokes sentence. I think you're familiar with the Reagan-Tokes sentence because the last time I had you back in 22, you also received a Reagan-Tokes sentence in that. And that's where you receive an indefinite sentence. So you're going to receive both a definite and an indefinite sentence. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections can, under certain circumstances, keep you up to the maximum penalty. So the maximum penalty for the F2s would be 8 to 12. We also have a mandatory fine in the amount of $7,500, no less than that. And this is subject to mandatory time. Counts.
I don't mean to interrupt you, but the Reagan-Tokes is going to apply to the most serious of the offense, and I did the plea form applying that to counts 5 and
Oh, that's
6.
right, because we have that's right, I forgot. We have an F1. So yeah, so it would be the maximum penalty that you could receive in the case that's the 11 to 17 and a half, because that's the most serious charge, meaning the F1. Do you understand that, Mr. Everhart? No? So the Reagan-Tokes attaches to the most, you only get one Reagan-Tokes, you only get one indefinite sentence, and that attaches to the most serious offense. Because the most serious offense that you are pleading no contest to is an F1, it's going to attach to the F1, not the F2. Do you understand that?
Yes.
Okay. So we have counts 3 and 4 are trafficking in drugs and possession of drugs. Those are each 5th-degree felonies. Count 5 is trafficking in a fentanyl-related compound, and count 6 is possession of fentanyl-related compound. Count 7 is trafficking in a fentanyl-related compound, and count 8 is possession of a fentanyl-related compound. Those are all first-degree felonies, meaning that they are punishable by up to 3 to 11. That's the minimum term, and the maximum term with the Reagan-Tokes is up to 16 and a half. I'm doing my math wrong. Up to 16 and a half years were they to keep you to the maximum penalty. So, moving on, we have counts 8 is possession of a fentanyl-related compound as a first-degree felony. Count 9 is trafficking in a fentanyl-related compound as a second-degree felony. Count 10 is possession of a fentanyl-related compound as a second-degree felony. Count 11 is trafficking in drugs as a fifth-degree felony. Fifth-degree felonies are punishable by anywhere from 6 to 12 months in prison. So we have counts 11 and 12, and then counts 13 and 14 are trafficking in a fentanyl-related compound and possession of a fentanyl-related compound. Again, count 13 is a felony of the first degree, and count 14 is possession of a fentanyl-related compound. That's a felony of the fourth degree. Kind of screwed all of that up pretty bad, Mr. Everhart, so if you don't understand where we're coming from, I'll go through it all again. That's why we have a chart here. But the essence of it is the most serious charge that you have, the first-degree felony, is the one that carries with it up to 11 years, but also that additional possible 5.5 years. Do you understand all of that?
Yes.
You're also subject to a mandatory period of post-release control. That means the adult parole authority is going to supervise you from anywhere from 2 to 5 years. And if you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. Yes, sir.
So you saying when I do get a judicial, I'm gonna be on post-release control, not probation?
If you serve your entire sentence, then you would be on post-release control. If you are released on judicial release, that means that you would be on probation.
And would I be able to, if I'm not out this way, would I be able to get that transferred?
Generally speaking, it depends on where you're trying to get it transferred to. Are you talking about in-state or out-of-state?
In-state.
So for an in-state transfer, if you live and have contacts in that county, let's say that you're from, I don't know, what county are you from?
It'd be Dayton, Judge.
Oh, okay. Montgomery County generally accepts our transfers. So yes, it can be transferred to a different county. I can't make you a promise in that regard, but generally speaking, we do administrative transfers for their supervision all the time. Does that answer your question?
Yes, sir.
All right, so if you get judicial release, then you would be on probation. If you serve your entire sentence, that's when post-release control would kick in. All right, before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty, plead no contest, and are found guilty, or are convicted following a trial. You have the right to confront all of the witnesses against you at the trial. You have the right to compel witnesses to testify on your own behalf, and you can't be convicted until every member of that jury is convinced beyond a reasonable doubt that you did this. If you want, you can waive the jury. I'll hear the case myself. I won't find you guilty unless I'm convinced beyond a reasonable doubt that you did this. If you enter a plea of no contest, then we're not going to have a trial. You're going to admit to the facts of this. A no contest plea means, Mr. Everhard, that you don't necessarily admit that those facts constitute a criminal offense, but a no contest plea is not a mini trial. So it's not like you would say, okay, I'm going to plead no contest, but I still want to dispute those facts. That's not how that works. Do you understand that?
Yes.
Okay. Because there's also something called an Alford plea. An Alford plea is different from a no contest plea. An Alford plea is a guilty plea that essentially says, I didn't do this, but I'm going to plead guilty to this charge because I don't want to face the possibility of the consequences following a trial. So I'm going to enter a plea of guilty so that I don't go to trial even though I maintain my innocence. Do you understand that?
Yes, sir.
All right, some people confuse those. Do you understand all of those rights that I've gone over with you?
Yes, sir.
Do you understand the rights that you're giving up by entering a plea of no contest?
Yes, sir.
Is this what you want to do?
Yes, sir.
Mr. V, what are the facts?
Your Honor, if the case were to proceed to trial, the state would call as witnesses Detective Gregory Spannell, Warren County Drug Task Force, Detective Dan Schweitzer of the Warren County Drug Task Force, Sergeant Brett Lee of the Ohio State Highway Patrol, and Todd Yoke, criminalist from the Miami Valley Regional Crime Lab. Testimony from Detective Spannell would indicate that in the days leading up to July the 18th of 2025, he developed information from a confidential informant that the defendant, in this case Curtis Everhart, then using the name Future, was involved in the sale of fentanyl. Detective Spannell engaged in both text and telephonic communication with the defendant and arranged for the purchase of a bulk amount of fentanyl. They made arrangements to meet on July the 18th of 2025 at 2830 State Route 123 in Franklin. That's located in Warren County in the state of Ohio. And they're engaged in a hand-to-hand transaction in which the defendant provided to Detective Spannell 11.9 grams of what was tested to be fentanyl-related compound at the Miami Valley Regional Crime Lab. That testing also indicated the presence of xylazine, a Schedule III controlled substance. The contact with the defendant, both by text and in person, was recorded. Following that, the defendant continued contact with Detective Spannell in regards to drug trafficking, and arrangements were made to meet again for the purchase of controlled substances on July the 21st of 2025. Defendant directed Detective Spannell to 2700 Miamisburg Centerville Road in Dayton. That's in Montgomery County, but a continuing course of criminal conduct that began in Warren County, Ohio. There they met and again engaged in a hand-to-hand sale of what was later tested to be 20.3 grams of fentanyl-related compound. Again, the contact by text and in person was recorded. Following that, the defendant and Detective Spannell again communicated and made arrangements for the purchase of fentanyl on August the 4th of 2025, again at 2700 Miamisburg Centerville Road. That's in Dayton in Montgomery County, but a continuing course of conduct that began in Warren County. Defendant and Detective Spannell again engaged in a hand-to-hand sale of what was tested to be 28 grams of a fentanyl-related compound. On August 18th of 2025, again, the defendant made arrangements for a sale of fentanyl to Detective Spannell. They again met at 2700 Miamisburg Centerville Road in Dayton in Montgomery County, continuing course of conduct that began in Warren County. And then they again met and exchanged for the purchase of what was later tested to be 13 grams of fentanyl, a Schedule II controlled substance, and also tested positive for xylazine, a Schedule III controlled substance. Again, the contact with the defendant, both by text and in person, was recorded. And finally, on September the 3rd of 2025, officers made arrangements for a buy, bust, and execution of a search warrant. Defendant made an offer by communication with Detective Spannell, offered to sell him 1 ounce, that's 28 grams of fentanyl, for $800. Defendant's vehicle was stopped, and he made an indicated to Detective Schweitzer as well as to Detective Spannell that he had intended to fleece Detective Spannell, that he did not have that fentanyl in his possession. A search of his residence, though, did locate 2.5 grams of a fentanyl-related compound. The defendant has a prior conviction for a drug offense. That's possession of heroin, Butler County case 2017 CR 20197.
Anything on those facts, Mr. Kirby?
No, Your Honor.
Mr. Everhart, did you hear all of those facts?
Yes.
Do you admit that they are true?
Yes.
Do you understand the rights that you're giving up by entering a plea of no contest?
Yes.
Is this what you want to do?
Yes.
What's your plea?
No contest.
I'm going to accept your plea of no contest. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Anything additional on the facts, Mr. View?
Nothing additional on the facts, Judge.
Mr. Kirby?
Your Honor, for the record, we would waive any formal pre-sentence investigation and elect to move forward with sentencing today. If I could be heard on sentencing, Judge.
Okay, I am going to find Mr. Everhart guilty of all 14 counts. Before we go into the matter of sentencing, we have a couple of issues that we have to resolve. First of all, we have the notifications regarding the Reagan-Tokes. Mr. Everhart, you had the opportunity to review the notification sheet with Mr. Kirby prior to the hearing today, right?
Yes, sir.
All right, we're going to go ahead and give Mr. Everhart this notification sheet right now, or does he have it already?
That's the only copy we have, Judge.
Okay. You'll have this to take with you, Mr. Everhart. I know I did kind of screw up some of the language regarding the Reagan-Tokes. That's why I like to give you the written notification, because the written notification is a little bit more thoughtful in that regard. Are you satisfied that you understand the Reagan-Tokes sentence?
Yes.
And are you satisfied that you have been notified about the Reagan-Tokes aspect of your sentence?
Can you say that again?
Are you satisfied that you have been notified about the Reagan-Tokes aspect of your sentence?
Yes.
Okay.
Judge, the only thing I would add is for Court's Exhibit 1, we would change the first line, "You are pleading no contest to an offense," that carries with it an indefinite sentence.
Oh, yeah, we have to change that. All right. Secondly, we have the issue of post-release control. There is a mandatory period of post-release control of anywhere from 2 to 5 years. That means, Mr. Everhart, if you serve your entire sentence, the adult parole authority is going to supervise you from that 2 to 5 year period. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. We also have this notification that I'm going to provide to you, and we're going to attach the Reagan-Tokes notification as Exhibit 1. We're going to attach the post-release control as Exhibit 2. But again, you have those and you can take them both with you. Second issue that we have is I have an affidavit of indigency, which is executed by Mr. Everhart. So I find that he is indigent for the purposes of fines and costs in the case. Next, we have the issue of merger. It is my belief that counts 1 and 2 merge, 3 and 4 merge, 5 and 6 merge, 7 and 8 merge, 9 and 10 merge, 11 and 12 also merge. Any dispute from the state on the issue of merger?
No, I agree with those, Your Honor.
Any dispute from the defense on the issue of merger?
No, Judge.
Essentially what this means, Mr. Everhart, is each time that you are charged with trafficking and possession, those counts merge, the possession will move into the trafficking, and the state is proceeding on the traffickings, right?
Yes, Your Honor.
All right, so in counts 1 and 2, 3 and 4, 5 and 6, 7 and 8, 9 and 10, 11 and 12, you're only going to be subject to a sentence in the trafficking, not in the possession. Okay? All right. With regard to sentence, do we have a jail time credit figure?
246 days as of today, Judge.
All right, Mr. View?
Nothing additional on it. I think we've covered everything in terms of what the court intends. If you would let me know which counts you intend to impose the sentences on, then I'll prepare the sentencing entry.
All right, Mr. Kirby, what do I need to know about this?
Judge, I agree with the 246 days of jail time credit. As Curtis indicated, he's 35 years old. He's from Middletown originally. I think that Curtis had an upbringing that makes him vulnerable for very bad situations like this case. He does want to put this behind him. He wants to maximize the time that he will spend incarcerated. I've already spoken with him at length about that. He intends to get his GED while in the Department of Corrections, along with other appropriate rehabilitative activities. He's already alluded to potentially a future motion for judicial release. He understands that that would be preconditioned on excellent behavior in the institution if we get to that point. Your Honor, I've spoken extensively to his family as well. His family is present. His sister Sierra is in the courtroom today. he has an excellent support system. I think that he intends to live in Dayton upon his release. His sister would like the court to know that Curtis has been a pillar in this family. He's been very helpful for her. He has a niece. He has other family members, an aunt that miss him and love him and provide an excellent support to him. His father was uninvolved in his life. His mother passed in 2017. That was a hardship on the family. And she has personally vowed that she will undertake helping Curtis out upon his release whenever that time is. Your Honor, we did provide the court with an executed affidavit of indigency. We would ask the court to waive the mandatory fine, credit him the time served, and impose a minimal sentence. That's all.
What do you want to tell me, Mr. Everhart?
All I can say is I'm sorry, and I didn't mean for this to come about, and it's just, I'm letting a lot of people down being in this situation, and I apologize.
All right, the court is going to impose a prison sentence. There is a mandatory prison sentence that goes along with this. So it would be counts 1. Let me make sure that I get this right. So it'd be counts 1, counts 5, count 7, count 9, and count 13. The court is going to impose a 6 to 9 year prison term. That is a 6-year mandatory prison term. And you're going to also receive the indefinite sentence, which is that 3-year Reagan-Toke sentence. So you're going to receive a 6 to 9 year prison sentence. I'm also going to, on count 3, sentence you to 12 months in prison. Count 11, sentence you to 12 months in prison. And on count 14, sentence you to 18 months in prison. And I'm going to require that all of these be served consecutively, because a consecutive sentence is necessary to properly punish you. Your criminal history suggests that a consecutive sentence is necessary to properly protect the public, and the overall sentence is not disproportionate to the conduct involved here or the danger posed by you. So the total would be a 9.5 to 12.5 year sentence. I do find that you're indigent for the purposes of fines and costs, so I am not going to impose any financial sanctions. We've already talked about the post-release control. You're subject to the mandatory post-release control. You are eligible for judicial release at some point in the case, and you have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the cost, they will all be provided to you at no charge. You have 30 days from which to file an appeal as a matter of right. 30 days from the filing of the judgment, entry of sentence. I anticipate that that's going to be today or tomorrow to file an appeal as a matter of right. Is there anything else we need to do? Is there anything that I forgot?
In this courtroom hearing, Curtis Everhart entered a no-contest plea to multiple felony drug trafficking and possession charges involving fentanyl-related compounds in Ohio. The court carefully reviewed the charges, explained Everhart's constitutional rights, and ensured that his plea was entered knowingly and voluntarily. Prosecutors outlined an extensive investigation conducted by the Warren County Drug Task Force, alleging that Everhart participated in several controlled fentanyl sales between July and September of 2025. According to investigators, undercover officers completed multiple hand-to-hand purchases, and laboratory testing confirmed the substances contained fentanyl and xylazine. During the hearing, the judge explained Ohio's Reagan-Toke law, which allows certain felony sentences to include both minimum and maximum prison terms. Several possession charges were merged into trafficking charges for sentencing purposes, reducing the number of separate convictions subject to punishment. Defense counsel highlighted Everhart's difficult upbringing, family support, and plans to pursue educational and rehabilitation programs while incarcerated. Everhart personally addressed the court, expressing remorse and apologizing for his actions. After considering the facts of the case, Everhart's criminal history, and the arguments presented by both sides, the judge imposed consecutive prison sentences totaling 9.5 to 12.5 years. The sentence also includes mandatory post-release supervision and credit for 246 days already served in jail. The judge informed Everhart of his right to appeal the decision and concluded the proceedings. This case highlights the serious legal consequences associated with fentanyl trafficking offenses and the significant penalties imposed under Ohio law.